I'm going to do a little short video here about land patents, patent grants, or letters of patent. And before I get started, I wish there would be an easy way to explain this in one paragraph, but it's a little bit more complicated, and that's because it has to do with law and property. And I'd just like to say I'm not a lawyer, I'm just an enthusiast, and I came across this through the Ontario Landowners Association, and this is a copy of a deed, okay? And I'm just going to read through this deed a little bit, if you bear with me, and we will get to the patent shortly. So what you're looking at here is a deed, okay? Now, somewhere around the year 2000, the province of Ontario went away from deeds and went to land transfers. So the language isn't the same, and many of us will wonder why. But if you have parents or uncles and aunts who have been in a property for a period of time prior to the year 2000, ask them if you can see a copy of their deed. I've heard stories that if you can find an older aunt or relative or parent prior to 1960, with the deed also came a copy of the patent. So here we go. This is the deed. This indenture, made in duplicate, the 4th day of December, 1980, in issuance of the Short Forms Conveyance Act between the seller, the town of Grimsby, and the region of municipality of Niagara, a married woman, okay, and hereafter called the grantor, okay? And that language you're going to see also on the patent grant or land patent. So the grantor is now party of the first part and sold to the purchaser, and it shows here in the regional municipality of Niagara, and spouse, and the same place as joint tenants, not tenants in common, hereafter called the grantees, or party of the second part. Also, the husband was also noted in this because the way the form was written, the wife and the husband who are selling the property have to both acknowledge that they are passing this on to the purchaser or the grantee. And it was witness in consideration of other good and valuable consideration for the sum of $1. Lawful money of Canada, now paid the said grantees to the said grantor, the receipt of whereas by her acknowledgement she, the said grantor, do grant and convey onto the grantees, that's the purchasers, as joint tenants and not tenants in common, all singular and certain parcel of land and premises situate laying in the town of Grimsby in the regional municipality of Niagara. So this gives a description of the land that's going to be purchased. This next part is where it starts to get a little bit interesting. This is on the deed, and again, this is just a blow-up of a copy of an excerpt of the deed. But if you can take a look, if you, like I said, if you can get your hands on a deed, possibly you have one, just take a little bit of time and read it. And here's what it says: to have and to hold onto the said grantees, that's the purchasers, their heirs and assigns. That means your children and anyone else that you assign or sell the land to and for their sole and only use forever. And forever means forever, as joint tenants and not tenants in common, and I believe that means that my wife and I are married rather than common law. Subject nevertheless to the reservations, limitations, provisos, and conditions expressed in the original grant thereof from the Crown. Okay, so we know that you have entitlement to the property, and that the people who are selling it to you, the grantors, are giving the grantees the entitlement that comes with the property. However, we don't know what that entitlement is because we need to look at the original grant from the Crown. I could get into this just a little bit more, just indulge me. The said grantor covenants with the said grantees that she has the right to convey the said lands to the said grantees, notwithstanding any act of the said grantor, and that the said grantees shall have quiet possession of the said lands free from all encumbrances. This means that there were no deals made by the original owners, the grantors, the people that the lands being purchased from have made, let's say, a deal with the Heritage Act or a Wetlands Act or something like that, and that the said grantor covenants with the said grantee that she will execute such further assurances of the said lands as may be requisite, and that the said grantor covenants the said grantees that she has done no act to encumber the lands. They're telling you that the land is free for you to have and use as your own, and the grantor releases to the said grantee all her claims upon the said lands. Means they can't come back and say there's money owing on it. It's free and clear. The land now transfers from the grantor, the seller, to the grantee, the purchaser. And we'll get into that when I show you what a land patent looks like, and the original one that I have a copy of. This is what a land patent looks like. I don't expect you to be able to read it, but I have it typed off in an easy read form. You got to remember, this was a standard form, and for the people that obtained a patent, what was required? First off, King George wanted the empire to expand, so he had to give something to the people to entice them to settle, to leave Europe, to leave Great Britain, and come here. And that was land. Land that was free in title and belonged to the people, with some exclusions which are explained on the patent. Also, the War of 1812. We always talk about the War of 1812, but the battle was part of it. But a lot of the soldiers, in return, ended up getting a patent, and that's the patent that I have here for my property. A fellow by the name of Thomas Fitzgerald fought in the War of 1812. Now, to obtain a patent, you were granted the land. The crown granted you the land. The crown or the king bought the land from the natives, okay? Although some people may debate that only if the natives were willing to sell it did the crown obtain it. There were no side deals. If you were a settler here, you could not make relationships with the Indians and purchase land. All land was purchased in the name of the crown. And then the reigning generals, Isaac Brock, Joseph Brant, these people, these generals, were in charge of granting land to settlers, to soldiers, and they had to stay on the land for 5 years, had to build a dwelling, had to clear a part of it and farm it. And after that, they were entitled to a patent. And that's what I'm going to review right here, is the patent. Okay? So the province of Upper Canada was basically Ontario. This was prior to Confederation. The War of 1812 was the British against the United States, who had fractioned off from the empire. Anyways, province of Upper Canada, George III, grace of God, United Kingdom of the Great Britain and Ireland, King, Defender of the Faith, and so forth, to whom all the prefiance comes, greetings. Know ye that we are special grace, certain knowledge, and mere motion have given and granted, and by these presents so do give and grant unto, this is the grantee, Thomas Fitzgerald, in the town of York, where this was documented, in the county of York, in the home district, Esquire, in this province, from His Majesty, the late Glengarry Infantry Tangible Regiment, his heirs and assigns forever, a certain parcel or tract of land situated in the township of Grimsby, in the county of Lincoln, in the district of Niagara, in our said province, contained by a measurement of 200 acres. So Thomas Fitzgerald is being granted 200 acres, and it goes on to say the lots and the concession numbers of the 200 acres. You've got to realize that the original lots that were in the townships were all approximately about 100 acres. Okay. The document goes on to say that together with all the woods and waters laying and being under reservations, limitations, and conditions hereafter expressed. Remember that part, that was on the deed, okay? Which said as follows, that the 200 acres budded and abounded, or may otherwise be known, and it now gives a description of the land in chains and how many degrees on a compass heading it would turn to find the stakes. I'm not going to get into the description of the land, but it is measured in chains, and if you have a patent, you'll be able to understand it. It goes on to say, to have and to hold the said parcel and tract of land hereby given and granted to him, the said Thomas Fitzgerald, his heirs and assigns. Same language that's on the deed. Forever. Saving nevertheless to our heirs and successors, this is the crown, all mines of gold, silver, but stricken on this patent are copper, timber, iron, and coal, that shall or may be hereafter found on any part of the said parcel or tract of land, hereby given and granted as foresaid, and saving and reserved to us our heirs, this is the king, his heirs and assigns, and successors, all white pine trees that shall or may now or herever grow, be growing on any part of the said parcel or tract of land, hereby granted as foresaid, provided that always no part of the parcel or tract of land hereby given and granted to the Thomas Fitzgerald, his heirs and assigns, be within any reservation hereto made and marked for us, our heirs and successors, by our surveyor. So, if the surveyor said there was something else of interest, it would have been noted there. Maybe there was a spring or a mineral spring or something of that nature. So, also on this patent, it has an exclusion. Provided, now Thomas Fitzgerald has to spend the 5 years to get the patent, and provided always that if at any time or times hereafter within the space of 3 years from the date of these presents, this patent, the said Thomas Fitzgerald, by any deed of bargain and sale, release, exchange, or otherwise convey, shall grant, bargain, sell, align, release, or convey all or any part of the said parcel of land, or hereby granted, then, in such case, this our grant for such part of land be given and granted to the said Thomas Fitzgerald and his heirs, as foresaid, shall be null and void. Anything hereafter contained to the contrary, thereafter, anywise notwithstanding. What does this mean? It means that the Crown said that he had to put the 5 years on it, plus 3, before he could sell the land as a grantor and pass it along. When this happens, when you see that exclusion, what it basically means is that unless you do a title search, we don't know what happened, because this document is dated for 1818. So 3 years later, we don't know if Thomas Fitzgerald sold the property. So you have to do a title search, which I did, and I found out that one part of the parcel, the first part of the 100 acres, he sold in 1826, and the second part was part of his estate after his death, which was sold in 1838. So a title search is important. But the point here now is that you see that there's entitlement. This came from the king, and it passed down through the British North American Act, and it was actually embraced into our Constitution. But for some reason, well, the powers that be don't want us to know about it. And the landowners, the Ontario landowners, if you go to that website and you can type in the search engine, in the search space, land patent, it will go to a page where you can find out how to obtain it, and there's a package, and get your land patent and go from there. And also you can find out more information about land ownership, property, entitlement, wetlands, the greenbelt. If you have a patent and you have your deed, the question now is, how do these apply? What gives the province the entitlement? And right now, nobody's been able to answer that, and this is before the courts, which is starting to seem to be a bit dragged out. But that gives you the basis of it, and maybe it'll get you interested. I know I have been. I have searched my title all the way from the beginning, from the patent, all the way up to my present deed. It's a little bit laborious. If somebody's interested, possibly, and the land office will let me go in there with a video camera, I can do a little bit of a video how to search your title out and give you some guidance to get started. I'm not a professional. I'm just a homeowner like anybody else. I live in the country, and I came across this and I just found it very interesting, so possibly you will too. Thank you for watching.